Hi, Lisa K. Donner here for LibertyNation.com, and with me today is our constitutional lawyer and legal affairs editor, Scott Cosenza. Welcome, Scott.
Thank you, Lisa.
All righty, so you have written an article that was actually picked up by the SCOTUS blog, very prestigious, by the way. I'm impressed. And you were talking about the Supreme Court decision on the Apple situation. Can you tell us a little bit about that?
The case is called Apple v. Pepper, and Pepper represents a number of Apple store customers, the App Store, who think that they paid too much money for various apps because of Apple having an unfair advantage, an illegal anti-competitive monopoly advantage. And so they wanted to sue Apple because they think they violated the law. But Apple argued that they didn't have to defend themselves against this type of case because they were immune from suit because the people weren't actually buying the apps from Apple, but they were buying them from the app publishers.
Well, I know we have a lot of readers that are Apple heads and use Apple. At Liberty Nation, some of us are not big Apple fans precisely because they seem to be very proprietary.
Yeah, this is about that closed environment, as a matter of fact. The only legal way, for instance, for iPhone users to use and install an app on their device because of the licensing agreements that they agree to when purchasing is through the Apple App Store. So there can be no competition. If you and I developed an app that was converted metric to standard cooking measurements or something like that, okay, we wanted to sell it for, 50 cents, for instance, the Apple App Store would not permit that. They have a minimum price, for instance, of 99 cents for any app that is sold in their store. So that's an anti-competitive, you might say, regulation.
Yeah, well, why is this not shocking? I noticed that a lot of my friends who have Apple can't just go ahead and download an app. They have to put in their Apple ID, which most of them don't know. And then what you're saying is then they have to go ahead and pay a higher price than us Android heads.
I'm laughing because that's a conversation I have with my mother quite frequently. It seems like the where is the Apple ID and what is the password? So yeah.
Yeah, and most of them don't know that you can set the settings so that you don't have to do that. But I think the problem is that a lot of these Apple people don't understand that they're buying into a very proprietary system.
Well, they may not be in the future, Lisa, because what this case did was the Ninth Circuit Court of Appeals had actually they had agreed with the people, the customers, if you will. So Pepper and company sued Apple, and they won at the district court level. The district court said Apple does not have to defend against these lawsuits because they're not the publisher of the app. And since the publisher of the app, with the exception of the 99-cent minimum, does get to set the app price, how the Apple Store works with their app vendors is as follows. If you and I had that metric to standard conversion app, we would have to pay a $99 annual license to Apple just to get into the store. But then it is a 30% cut. That's what Apple takes of all app sales from the store for third-party publishers. They publish their own apps, which they get 100% of the money for. But for other apps, they get 30% cut. And all prices have to end in 99 cents. That's another rule of the store. So
right, but just to be clear, the Supreme Court isn't saying they are going to make the decision for Apple. They're just saying that Apple can now be sued.
That's exactly right. Apple was able to get out of being sued under the decision from the lower court. The Ninth Circuit decision overruled that lower court order and said that Apple would have to defend itself. And that Apple appealed that decision to the Supreme Court, and the Supreme Court said, no, Apple, you do have to defend yourself. These suits will be allowed to go forward. We're not judging now whether, in fact, there's merit there in the suit. There may be, they may be dismissed on other grounds, or they may lose either at trial. But one thing is for sure, Apple's going to have to defend itself now against these charges that they have acted anti-competitively.
Right. I thought it was interesting that you said that Brett Kavanaugh, the new Associate Justice, had to join the liberals. But to me, I'm surprised that the conservatives were for this.
So there's been a lot of sort of trying to read the tea leaves because Kavanaugh's new, and we're all of us who pay close attention to the court are trying to figure out where his jurisprudence is going to be now that he's not hemmed in by the requirement to follow stare decisis, because he is a Supreme Court justice now, and he can write his true feelings or thoughts about what the Constitution holds. So there's so much attention paid right now, an outsized amount of attention paid. And I tried to approach the opinion as to whether or not it was a conservative or liberal or leftist position for either one of them. And I don't think this case tracks quite along those lines where we can then project into the future, about his other things. But it is an interesting side note. Ruth Bader Ginsburg was also on this side of the opinion, and as the senior most justice in the minority, she had the right by tradition at the Supreme Court to assign the opinion. So she gave it to Kavanaugh. So that was just sort of an interesting wrinkle as well.
Well, I kind of want to know, what is the conservative point of view here? Because it does seem like Apple is, raking their people over the coals.
Well, I can tell you this, generally speaking, the sort of Federalist Society view of these things is, if it's very easy for lots of people, and especially trial attorneys, especially class action lawsuit attorneys, to make money off a corporation, and the people to see not much money, then I think the conservative position then would be to favor the Apple side of things. I can tell you, Lisa, that the libertarian position is quite clear, which is that antitrust laws themselves are unconstitutional. And Apple, even though we may find their behavior odious and anti-competitive, should have the legal right to demand anything they want, as long as they're upfront about it. They don't have the right to lie or cheat about it. But if they say, again, this is the libertarian position, would be, if you want to use our iPhone, you have to follow whatever rules we set for the apps that you install on them. Well, that's up to the consumer to decide. But that's sort of the conservative position here. But there's room, I guess, at least for Kavanaugh to see it another way.
All right, Scott, thanks so much for joining us. Read Scott's fine articles on LibertyNation.com and the prestigious SCOTUS blog. Thanks for joining us today, Scott.
Thank you, Lisa.